This tutorial is for the response to petition for dissolution. It is form FL-120. The purpose of this form is to let the judge know that you are interested in contesting the dissolution, especially common when there is a distribution of property that needs to be decided by the court, or if there are issues of child custody or visitation. You have 30 days from when you were served with the petition to file this with the court. You may still file it after 30 days, but you run the risk that the other party has obtained a default against you, which means that you do not get to contest property or related issues. So file this on time in order for the judge to consider it with full authority. So to fill out this form, you will put your name in the upper left corner there. Don't worry about firm name, that's for attorneys. Put in your street address along with the city, the state, and your zip code. It is encouraged to put in a phone number and email address, but not absolutely mandatory. The court is Siskiyou. The address is 311 4th Street in Wairika 96097, and the family or branch name is family/civil. The petitioner is the name of the person who filed the original petition. If you are filling this out, then you are the respondent. You will always be the respondent in this matter. So every time you're filling something out, keep in mind that you are filling it out as a respondent. Okay, so this is a response to the petition for dissolution. If you are agreeing generally to being divorced, then you can also mark the box that says and request for dissolution of marriage. You should also put in the case number over on the right hand side here. The case number will be on the actual petition. Scrolling down here, you either need to mark that you are married, box A, or that you are in a domestic partnership, box B if the partnership was established in California, and box C if it was established somewhere outside of California. The residence requirement, either you or the petitioner has to have lived here in Siskiyou County for the last 3 months and for a total of 6 months. If that is not true for either of you, you may leave that blank, but if it is true for you or the petitioner, go ahead and mark the appropriate boxes. Scrolling down to paragraph 3, if this is a marriage, mark box A. If it's a domestic partnership, mark box B. Under box A, you'll put in the date of marriage. You'll put in the date of separation, and then calculate how long you were married in terms of years and months. Date of separation is the date that you thought the marriage was broken beyond repair. It does not have to match the date of separation that the petitioner put at this place in the petition. If you think it's a different date then you should mark that now. Scrolling down to paragraph number 4. If you and the petitioner do not have any children under the age of 18, then mark that box. And I mean children together. If you have children from another relationship, they do not have to be involved in this divorce action. This divorce action is for children of the marriage. If there are children, mark box B and fill in the names of the children as well as their birthdays, their age, and whether they're male or female. If you have children, you will need to complete this form FL-105. You can find this also on the website, along with a tutorial similar to this for filling that out. Okay, let's talk about paragraph number 5. So, respondent, which is you, contends that you were never legally married. Well, if that is your contention, then mark A. If you disagree with the petitioner's reason for getting divorced, for example, let's say the petitioner says that you are physically incapable, then you can mark this box to deny that and have the court determine whether that's true or not. Generally speaking, the divorce will go forward. California does not have a policy of requiring people to stay married to each other when they don't want to. It is most likely that at some point the divorce will be entered. It's just a matter of whether and what to do with any property or children. So the most common way to fill this in would be to mark box C, that you are also requesting either divorce or separation, and that the reason is irreconcilable differences. However, if you disagree with that, it is okay to mark one of the other boxes. Just know that that will require a little bit more work on your part, and it is a little bit less common because of California's policy of allowing people to get divorces without contest. Okay, down to custody and visitation. If you and the petitioner do not have children together, or the children you do have are grown, then you can skip number 6 and number 7, and you can go straight to spousal support. If you believe that the petitioner should pay you spousal support, go ahead and mark box A and mark the spot for respondent. You will have to offer some economic evidence of your income and expenses in an effort to establish how much you make and how much the petitioner makes, and allow the judge an opportunity to order the petitioner to pay you spousal support. If you have been married less than 10 years, you may mark the box to terminate spousal support, which just means that neither of you will ever pay the other one of you spousal support. If you've been married longer than 10 years and you don't know if you want to have spousal support now, mark the box for reserve, and then that allows the judge to make a decision sometime down the road if it comes up. In California, there are 2 types of property to consider in a divorce. One is separate property, which is everything that you or the petitioner owned on your own before you were married. For example, Your baseball card collection from when you were a kid is still your separate property, even though you are now married. If you have any sort of property or assets that you think is separate property that you want to keep as separate property, you need to identify it here. Your choices are to first mark box B, which lets the court know that there is separate property. Then you can either fill out this declaration form, or if the number of items is not too many, fill out the list there by just listing out what the items are. And over here it says confirm to. So if it's something that was yours, let's just go with the baseball cards, then you would want to confirm it to respondent, because you are the respondent and you want to be keeping the baseball cards. Now, all of the things that you purchased and you bought and that you have, including debt that accrued while you were married, would be community property. If there is no community property, or if you and the petitioner have already divided the community property, it would be fine just to mark the box that says there is no community property. However, if there is anything at all that you will need the court's assistance in dividing, mark box B, then figure out if you're going to do the property declaration form, or if you will just list out the items that you have. Either way is fine. The property declaration form is a bit more detailed and allows for I think it gives you more choices in terms of what you are putting down. The next thing to note is under paragraph 11. If you are handling all of your own paperwork, then you do not have attorney fees and you do not get to mark the box for attorney fees. If you do have an attorney, he or she should be filling out this form for you with a little bit of guidance, and then you can mark that box. If you would like to have your last name changed back to your pre-married name, you will mark box B and then write in your name how you want it to be after the divorce. Then at the bottom, print your name down here and then sign it. Oh, also don't forget to do the date. So that is the response. You will then have to make 2 copies of this. So you have the original and you have 2 copies. You will file the copies with the court, and then you will have to serve one of the copies on the petitioner. Because this is a response, you can do the response by mail, or I mean proof of service by mail, and we will do that tutorial later.